Hello, my name is Alyssa, and I have been tasked with presenting and providing recommendations on the local authority over the hydraulic fracturing that has been approved for just outside of our city limits. I will begin with a brief overview of what fracking is and what we may do as a city to help appease the residents whom will be affected by these operations. Hydraulic fracturing, also known as fracking, is the process of breaking up shale underneath the Earth's surface to extract natural gas supplies. A series of holes are drilled into the ground, and these holes are pumped with a water-chemical mixture that breaks or fractures the rocks, releasing natural gases, which are then collected and used for energy purposes, such as heating homes, running vehicles, or providing electricity. However, there are concerns with this process. There have been studies that show fracking has been linked to a decrease in water supplies, and the water used in the process can seep through the soil and end up in our water supplies of the city. This can present a potential problem for the residential area nearest the operations, as we are not aware of what the water chemical mixture is that is being used, as it is not legally required that businesses release that information. Any efforts to prevent, help, or negate these effects will be outlined in further slides based on the recommendations of the Environmental Protection Agency. Another point of concern is the noise and light pollution that will come with this operations, as it is close to that residential area. Operations do not cease during nighttime hours, and hydraulics run 24/7. It is a loud process, and the light is necessary. So again, this will carry an effect to the neighborhood nearest the operations, and there will be recommendations for that in future slides. As stated in the previous slide, the Environmental Protection Agency provides regulations for the pollution that is caused by fracking. The EPA is working with states and other key stakeholders to ensure that natural gas extraction does not come at the expense of public health and the environment. And the agency's focus and obligations under the law are to provide oversight, guidance, and, where appropriate, rulemaking that achieve the best possible protections for the air, water, and land where Americans live, work, and play. The agency will be involved in the process of the hydraulic fracturing and will establish a framework for which to address and rectify the negatives that do apply to this process. They will ensure the safe management of wastewater, stormwater, and other wastes from fracking activities, and a number of different possibilities are available for the proper disposal of the contaminated water to prevent it from seeping into water that is reserved for the city. They will also be actively involved in making sure that the states and the localities remain in compliance for the environmental impacts that occur from fracking. This does bring about the possibility of a delegation by the Environmental Protection Agency and the state, and we would be required to carry out the administrative tasks that are laid out by the federal and state regulations. This delegation is proper, as it is only the power to implement the policies, but not a delegation of any lawmaking or discretionary power. All of these decisions and all of these guidelines must be followed exactly, and there is no power to change the legislation, only to apply it. This would allow the authority to create the above-ground ordinances that might work for the benefit for the nearest residential area, which I will cover in further slides. There is also the proprietary nature of hydraulic fracturing to take into account, as it is corporate, private, and business-like in nature, as it is an arm of the federal and state and local governments through the legislations that have been passed. So it can be held liable for the effects that it produces on the community, and because it does not provide for the welfare of the citizens of the state, so it must be held to a higher standard. We can help control this higher standard with our home rule authority. It is necessary to define what the charter states is our home rule authority. It grants us the necessary powers for the government and administration of any local affairs. However, we are still subject to general state laws, and matters that are of statewide concern remain under the jurisdiction of state law. It is also important to point out that Dillon's rule states that any powers that are not expressly stated, fairly implied, or absolutely essential are not within the locality's authority to act upon. If it is not stated, we do not have the power to use it. Home rule is also usually limited within geographical boundaries, and we have no extraterritorial powers outside of our own boundaries unless we have express authorizations from the state. However, extraterritorial businesses can often affect our city residents, and the city then may have an obvious interest in protecting its residents. So it does fall under the local legislative authority to impose restrictions on business conducted outside of the boundaries, because the city has an obligation for the safety and protection of our citizens, and we may impose reasonable conditions and limitations. However, we do have to take into consideration any state preemption, which was outlined in House Bill 40. So when something is preempted, the state will have passed legislation to cover all of that field of activity or regulation, and there's no room for city law on this matter, and it is covered by the legislation and considered a statewide concern. House Bill 40 was passed in 2015 by the Texas State Senate and clarifies that the state is the ultimate authority when setting policies related to oil and gas exploration, and it preempts the authority of the local government. The Cooley Doctrine shares this opinion and states that the states share the power of the federal government to regulate national commercial matters, which includes oil and gas, and preempts local authority. House Bill 40 expressly states that the authority of the municipality or other political subdivision to regulate an oil and gas operation is expressly preempted, except that a municipality is authorized to enact, amend, or enforce an ordinance or other measure that regulates only surface activity that is incident to all net oil and gas operation, is commercially reasonable, and does not effectively prohibit an oil and gas operation, and is not otherwise preempted by state or federal law. So while the city is unable to do anything that inhibits the industry, we may impose certain restrictions based on the proprietary nature of the operations. It is my recommendation as we move forward that we focus on ordinances and pass those based on the above ground pollution, such as the noise and light pollution that comes with the oil and gas operations, as these will be the most noticeable factor affecting the neighborhoods nearest to the site. And as long as these ordinances do not ban, limit, or otherwise regulate an oil and gas operation, or contradict any state and federal law, it will be upheld by the courts. For example, state law was upheld in northern Texas, where the cities tried to ban fracking near their city limits, and it was found by the courts that they were outside of their authority as a locality, and state law was upheld and allowed the oil and gas industry to continue their operations, which was a leading reason to the passing of House Bill 40. It is also necessary to point out that it has been biblically stated for everyone to be subject to the governing authorities that have been ordained by God, because the authority of government is rooted in the authority of God, for there is no authority except from God, and all authority is established by God, and governing rulers are considered servants of God. So it is important that we follow the state legislatures and what they have set out for us to follow. With these ordinances, they must set forth with clarity some norm or standard by which all persons may know their rights or obligations thereunder. This is known as a rule of reasonable definiteness and certainty, and it applies to any municipal legislation affecting the lives or properties of the citizens. It also affects the business of the oil and gas industry, as they are entitled to know all applicable restrictions, but again, I must emphasize that these ordinances cannot limit or ban the operations, but can only impose restrictions on how they affect the residents of the neighborhood of the nearest site. A quick recap of this presentation: the oil and gas operations exist under the federal and state authority. The Environmental Protection Agency guidelines may have been delegated to the state, and then from the state to the municipality, with explicit directions on limiting water and air pollution, and it is expressly forbidden to interfere with the oil and gas operations in the state of Texas. However, ordinances may be passed to regulate the above-ground noise and light pollution issues, so long as they do not interfere, limit, or ban any operations. I thank you for your time, and I hope this clarifies the situation that is presented to us today.